Sorry to keep you waiting, Mr. Makamu. How are you?
I'm very well, and yourself, Chief Justice?
Fine, thanks.
Thanks.
You were here not very long ago, so you are familiar with the procedure.
Yes, sort of.
At least you have an idea what to expect. You would not be nervous.
Yes.
Good.
Thanks, Chief Justice.
All right. I recall that you have many degrees, many law degrees, 3 in all.
Yes.
Legal qualifications, rather. You did a deep juris, then did the degree, the B juris, and then you did your LLB.
Yes, and I just did not complete my LLM.
Yeah, you did mention that. You still have not done anything in that regard.
Yes, when I wanted to continue, the department closed because the professor was running it immigrated to another country. Yes.
Okay. So your career has been in public sector. You've been with the Department of Justice since you started.
Yes.
And that was in 1980.
Yes, Chief Justice.
As a court interpreter.
Yes, Chief Justice.
I'm tired, sorry. It's been a long morning. Court interpreter, then you just went through all the ranks. Clerk of the court, estate clerk, and did many things. Then you went into prosecution until you became a magistrate.
Yes, Chief Justice.
And how long have you been a magistrate?
Almost 40 years now.
Yeah. And you're a regional magistrate.
Yes, Chief Justice.
As a district court magistrate, did you get a chance to do civil work?
No, Chief Justice. During those days, yes, I eventually did, but when I was still in Guyana, that was a domain which was specifically for the chief or the head of the office.
Yeah.
And not everyone else could do it. And the civil matters were very, very few. That's why they held it very close to their chest.
Yeah.
But when I became head of the office in Benoni, then I started to do civil work. I knew that I had not done much, so I started to engage myself in it, and that's where I picked up a lot of experience in civil.
And in the regional court, there is a bit of civil work there, isn't there?
Yes, we do civil and criminal and divorces.
You've acted as a judge on a few occasions.
Yes, from 2016, but the majority part of it, I was seized with a matter that was very, very long, a white-collar crime, which fortunately I finalized.
Okay. So what kind of work have you been exposed to during these acting stints?
Civil trials, opposed and unopposed motions, those were the only ones. Well, and the appeals, and mainly the criminal appeals, being on the full bench and full court.
So would you say you've had a fair amount of exposure in the civil space?
I will say so, Chief Justice. Yes, I might not have done the agent court and other areas, but that was due to what was identified, I believe, by the judge president and the deputy judge presidents, that I was strong in criminal and in criminal law, and they did not have much experience in that regard, and they assigned me there, and I was happy to do it, and I'm still very happy to do criminal work as well, but it doesn't mean that I cannot do any other civil work.
Yeah. Have you written any judgments?
Yes, I did.
In civil and criminal law?
Yes, I did, Chief Justice.
About how many? as an acting judge?
When I try to count, I think there are 47. Yes.
Have any of those reported?
Not as far as I know.
No. How old are you?
I'm 66.
67, next birthday.
Yes. Chief Justice.
I raise this because it may be an issue for in some quarters, and I want you to address it squarely while you are sitting here. If the fact that you are that age should disqualify you from being appointed.
Chief Justice, I dedicated my life to the judiciary now, and I believe I've done more than enough in the lower court, and I have already gathered a bit of experience in the High Court, and I believe that the remaining years of my life, which could be 8 years or more, I will still contribute meaningfully to the High Court bench. So instead of wasting this, my 8 years that is left, I rather be utilized effectively, especially in the higher court.
You have mentioned some health issues in the application form. Do those impede the execution of your judicial duties in any way?
I will respond in this way, that my last real sick leave was in 1999. And the next sick leave that I had was during 2021, 2020, during the COVID. Just because I tested positive for COVID, I couldn't go to work. But other than that, I am not bothered at all. It's something that I live with, and it's very much under control.
Yes, so you get along just fine with the rest of all of us.
Yes, Chief Justice. I think I don't even know that I've got it. I just do the routine that I've been given, and I've never had an issue with it, even on a single day.
Well, it would not be fair. Well, let me just ask what you would add this time around, seeing that you've been here before and was unsuccessful. What do you have to add that you have done since October 2023 that would plump your CV up just a little bit?
Well, Chief Justice, I've done unopposed applications, I've done opposed, and with the criminal case that I was seized with, I have learned quite a lot as well, which experience I believe that it will come very handy in dealing with any other matter, especially the criminal matters. So I believe that experience that I have now will be very much beneficial to the High Court bench.
Well, the GCB has some misgivings about the quality of your reasoning and writing of judgments.
Yes, I saw that, Chief Justice. However,
how would you respond to that?
In this field, we keep on learning. And one thing certain is that you don't normally have somebody holding your hand. So these critics that I received now, because in 2022, I did not have the benefit of seeing them. And now I have seen them, I'm able to see where I am lacking. And that's exactly where I'm going to work very hard to make sure that my judgments are better. And they indicated that it seems like it's a little bit better than the previous one when they saw the current judgments. And it was without even the benefit of the critics. So now that I know those critics, then definitely I'm going to work very hard to make sure that my judgments look much better.
Have you taken advantage of the judgment writing seminars offered, for example, by the SAJ?
Yes, I have. I've attended them. The only thing is that when you attend those that are offered by SAJ, focusing on the lower court, you don't get the same quality of advice that you get when you attend the one that is provided for judges. However, when I was in Johannesburg High Court, every Thursday, or most of the Thursdays, there is training that is going on in there. And I've already since learned quite a lot. The last justice who trained us was Justice Nafsa, who gave us a lot of pointers, which I felt that they benefited me a lot. And I feel I'm still ready to continue and work very hard to get more skills in my writing. And I promise you, Chief Justice, I believe the next judgment that you'll get, because of the benefit of GCB's comments, will look extremely different from the previous ones.
Well, small credit is that they do say they discern a slight improvement. So it's not as bad as it was previously in their view.
Yeah, thank you, Chief Justice. That's why I say it was even without the benefit of the critics. Maybe they thought I saw their criticisms in 2022, and unfortunately I had not seen them. So now that I've seen these ones, they will say something much better in case they have to see my judgments. And whenever I'm sitting in court, if they meet my judgments, they will definitely realize that there's a huge improvement. Thank you, Chief Justice.
All right, Judge President Mlam.
Thank you very much, Chief Justice. Absent Tata.
Absent, Judge President.
Minjani.
Ifukile minjani.
Tukile.
Isona.
I don't want us to beat about the bush. The predominant area of the High Court work area you've been allocated is criminal trials, am I correct?
Yes, JP.
And that's because of your specialization in criminal work, especially as a regional magistrate, am I correct?
Yes, JP.
Now, you've had occasions, like you've had 3 weeks in the unopposed motion courts, and that's reflected in the judgment list that you've circulated where you show draft orders and stuff. And you had 2 opposed motion weeks.
Yes.
Right.
Yes, JP.
And you've written judgments.
Yes, JP.
What I noticed in those judgments is none of them were more than 3 months.
Yes, JP.
Right. Despite the fact
maybe,
that you are a criminal specialist.
Yes, JP. My personal drive is that whenever I say the judgment is reserved, immediately in my own diary, I write when it's going to be delivered.
Yes.
And I strive to make sure that it's delivered by that day, yes, or even earlier.
Now, you've been busy with a trial, State versus Dube. When did you get that trial and how long did it take you to run that trial?
It started on the 31st of July, 2018. But in earnest, it started on the 1st of August. And I was seized with that matter, and I delivered my judgment on the 13th of November 2023, and my sentence on the 19th of April 2024.
Right. It involved something like, what is it, 11 accused?
Initially, there were 13, and then 2 became Section 204 state witnesses. And as time went on, unfortunately, 2 of the accused also passed on.
Yeah. Now, someone will ask, how does it happen that it takes you a trial from 2018 to 2024?
Whoever has dealt with a case that has got multiple accused persons and multiple counsel will know that it's not an easy sailing. One other very unfortunate thing in this matter, one accused was not in her best health when we started. And she kept on being absent because of that. And we couldn't proceed without her.
Yeah, I think what I want you to tell the commission is there are other issues that made sure the trial doesn't run, that kept on disrupting this trial, other than sickness, counsel, and yourself. You were always available, but I was tracking this matter and I issued a directive that it run until it finishes.
Yes, JP.
But I think what I want you to tell the commission are the countless applications for any conceivable issue that you had to deal with as the trial judge in that matter.
On a lighter note, I always say when I cough, there will be an application. When I sneeze, there will be an application. For every little bit of thing that happened, there were applications. I believe in this matter, there were more than 20 applications, all in all.
And when you deal with them, you stop the trial and look at the application.
Yes, there were.
And then you wrote judgments about all
Yes,
those applications.
yes, that's exactly what was happening.
As a matter of fact, there's one application that was launched a few days ago trying to interdict you from sitting there.
Yes, I was informed that I was not supposed to be privileged and sit in front of you.
Yeah.
Because of that, but unfortunately they were unsuccessful as well.
Yeah. Were you in court when this matter was heard, or do you know what the judge said about that matter?
I only read in the media like everyone else. I have not seen the actual judgment. But what I know is that there was a scathing attack from the DJP who had the matter, because this matter was not even necessary to be brought before court, and he was even not very happy with the counsel who took instructions to bring the matter that is definitely not supposed to be there.
Right. My last question, in a sense, this matter, it took so long, but you couldn't take any other allocation because you would be available to deal with this matter. So you had to focus on it and finish it. Am I correct?
Exactly, JP. The only time that I took some other work is last year's second term, when most of the council, because initially there were 7 council in the matter.
Yes.
And there was a complaint that they don't have an opportunity to do some of their other work and their practice were collapsing. So I accepted the work to go and do civil for the second term last year in order to accommodate them. But other than that, I've always been sitting.
Right.
And one other last thing is that there were 2 accused who were self-representing, and they were both in custody. And they brought application after application regarding the manner in which we sit, and then they are taken back to the correctional facility. And when the protocols of them being checked in are complete, it will be well over 12 midnight. And they indicated that that hampers their preparations, because they need to prepare for the next day and also to be able to focus during the trial. And then there was a conscious decision that was made. We agreed with all the parties. We started at 8:30 in the morning, and at 1 o'clock, just after 1, before 2 o'clock, we'll adjourn for a day. That also contributed. Thank you, Chief.
Yeah. Just as a matter of record, your conviction and sentence of these accused has been the subject of leave to appeal to the Supreme Court of Appeal and to the CC. Am I correct?
Yes, JP.
And with what result?
They were unsuccessful, JP.
They were unsuccessful.
Yes. Even in all the applications that were brought during the trial, they were unsuccessful.
There were applications for leave to appeal on any ruling that you made.
Exactly, JP.
Thank you very much. Thank you, CJ. I've got no further questions.
Thank you, JP. Premier?
Thank you so much, CJ. I'm covered. Thank you.
Judge President Tlalitsi?
Thank you, Chief Justice. Mr. Makamu, here am I.
I'm trying to look
Straight.
This room is very big.
Look
Thank you.
straight.
Now I can see you. Thank you. Thank you, JP.
Thank you. There's no doubt that you've got extensive experience at all levels of the judiciary, from the magistrates court, regional court, and in all these courts you've played a leadership role, and also on the organized bodies of these levels of the judiciary. especially the Jawasa and Armasa.
Aramsa, yes. Thank you, JP.
And,
Yes,
and,
it's
and, and
true.
you, I can say you have seen it all.
Yes, JP.
Just from an objective point of view, I would want to get your opinion on something, and which is always being said, that there is no distinction between the work of a judge and that of a magistrate. For now, put aside the remunerative part of it, but let's look at the gist of the work, because the public have been told that there's absolutely no difference, only that the others are doing reviews and appeals. Given your experience having acted and operated at all levels, what will your view, or what would you want to share with the Commission?
JP, for one person who have never experienced the other level, will come with any kind of allegations without knowing the real situation. Yes, they say the High Court judges, they don't have much work. They are just driving around and having holidays without knowing exactly the extent of work. Definitely, there's a huge difference between a lower court and the High Court. The district court is much, much lesser. They've got a huge volume of work, which they dispose very quickly. The regional court is a little bit harder because, in essence, each and every judgment you have to write. But the quality of that work is nowhere closer to the quality that is expected in the High Court. So the research and the quality of work that you put behind that particular judgment is much higher in the High Court. So it's not exactly the same. It's not true, it's misplaced, that particular fact. Thank you, Jay.
Yes, we, as the heads of court and from our judicial accountability reports, we've noticed that there's a serious backlog, particularly with regard to criminal work. Given your experience and expertise in criminal work, if for the remainder of your life, I'm just making it a hypothetical example, you were to dedicate it to deal with these backlogs in the High Court criminal bench, would you be able to dent it and put much effort?
I will not have any problem at all, and the progress will be very significant and it will be there to be seen by all. I will definitely make a huge dent in that particular aspect. Because one other thing that causes the delays is the knowledge and experience of knowing how to deal with situations. And when you have control of your court, you are going to make sure that things goes very smoothly. And that will be done. And I have no doubt. I will give one very simple example. When I was in the High Court, not so long ago, where you start a criminal trial, and some counsel, they will still come with the old-fashioned thing to say, we plead not guilty, we reserve our right to remain silent, and don't want to say anything. And it's a murder case. Or they say, we dispute everything. Then the next question I will ask is, do you dispute that Mr Makamu was killed? He's the one who died. No, we don't dispute. Do you dispute that he had bullet wounds on his chest? We don't dispute. Then I will say to them, to guide them, you must make some necessary admissions so that we may not waste time to prove that that person who died was Mr Makamu, and that very body had some wounds or gunshot wounds in his chest. So that in itself is one step towards trying to make sure that criminal trials are dealt with speedily. Thank you, JP.
Thank you, Mr. Makamu. Thank you, Chief Justice.
Commissioner Godsell?
Good afternoon, Mr. Makamu.
Good afternoon, Commissioner.
You are the Deputy Commissioner of the Magistrates Commission.
Yes, I'm the
Is that
Deputy
correct?
Chairperson of the Magistrates Commission, yes.
Okay. Now, in dealing with the sanction in the Hingsa matter, Mr. Hingsa was the Chief Magistrate of Bloemfontein.
Yes.
Late last year, the Commission was on the point of not removing Mr. Hingsa from office for gross misconduct. And it is said that it was done because of a view by half of the commissioners that they didn't agree with a finding on the merits by the tribunal. These charges also included sexual misconduct. Were you part of the body when it took that decision?
I was definitely part of the body.
You were. And
Yes, and I may even enlighten you in the fact that the first thing that caused a huge debate was that this matter, the allegations of rape, were reported to the local police station, and the local DPP declined to prosecute. And they escalated it to the National Director of Public Prosecutions, and they declined to prosecute. Then we decided through the ethics committee to charge him with that misconduct. But then there was still a little bit of a debate that are we better investigators and prosecutors than the NPA? Are we not undermining the authority of NPA, that's a Chapter 9 institution? So that was the debate in the beginning. Then when it came to the actual hearing as well, there were few things that were questioned by the commissioners that they were not happy with in the conduct of that particular inquiry. But then at the end of the day, we sat down and we even sourced a legal opinion. And we realized that even on the part of the accused person, there were some shortcomings during the trial. For instance, he did not even testify. He closed his case without testifying. Then without even testifying, that really leaves him with a huge task. And as a result, after that particular revelation, we unanimously decided to go with the tribunal's decision.
but can you explain to me, and that was the second part of my question, what authority the Commission has to interfere with the decision of its own tribunal? It does have the power to interfere with sanction, but does it have the power to interfere with a finding?
That's exactly what was discovered when the legal opinion was sourced. And then the whole commission relented on challenging the findings of the tribunal.
So what was the finding of the opinion, in the opinion?
Was that the Minister's Commission cannot interfere with the decision of the tribunal.
Okay, and so you confirm that you were part of the Commission?
Yes,
who then
I was.
interfered with that decision and then referred it to the Minister?
Yeah, the only thing that I will not try to say now is whether I was for or against. But the fact of the matter, I was part of that commission that came to that particular decision. And at the end of the day, a recommendation was made to the minister, yes.
Because the charges were gross misconduct and they included serious allegations of sexual misconduct.
Actually, the main charges were two rape counts on one victim on different occasions. But I think the commission now is more enlightened to that, including myself, and we know exactly where we stand. Thank you.
Thank you, Chief.
Commissioner Nkaito.
Thank you, Chief Justice. Mr. Makamu, I just want to put some of the objections. The Judge President has put some of them to you, but the objections made by, I think, 3 of the accused in the trial that you ran, a lot of them do not have any substance, so we've considered and rejected them. But there is one you should probably explain where they say that you lied in your judgment when you claimed in paragraph 155 that you had already given a comprehensive judgment into the admissibility of certain of the data evidence as to whether it would be real or documentary evidence. And therefore, on that basis, you're not suitable for appointment as a judge.
Correct, Commissioner Mugaitobi. There's nowhere throughout all those multiple applications where I did not give a ruling. And initially, when they brought this particular application that I should regard the data evidence as real evidence or documentary evidence, I gave an extempore judgment, which is there in the recordings. And then at the time when they applied for my recusal from the matter, they tabulated different reasons under different headings. And one of them was that I did not rule as to whether the data evidence was real evidence or was documentary evidence. And in my judgment for recusal, I then pointed out that I have already made a decision that it was real evidence. The only thing is that it was not a 20-page reasons on that particular aspect. And the reason for that is that when you are still going to give your judgment, if you expand a lot more, you sort of trying to give away what you think the case is heading to. So I did write that judgment, and the judgment is there. Then they also applied that I should revisit my decisions. Most unfortunately, I gave an extempore judgment, which was delivered. I can't remember whether it was the 21st of October. Unfortunately, the machine malfunctioned on that particular aspect. And even my extempore judgments, they are not extempore directly from my head. I drafted those particular judgments. And I don't know what actually happened that day, because even my laptop crashed that particular time when the recording machine also malfunctioned. But the fact of the matter is, I even wrote on my bench book the order that I made on that particular day. So there was no way in which I never pronounced my decision regarding the admission of the data evidence. It is not correct what they said. It's an insult to everyone else who was there. And to try and cap it, to try and put a little bit more on it, there were 7 counsel in that particular matter. They are not just people who come from the street who don't know what they are doing. There's no one counsel who complained about that particular aspect. One of the accused, he now employed another firm of attorneys who were not part of the proceedings from the onset. But those who were available, who were part of that particular trial, they know exactly that that is not true.
Yes.
I hope I answered you.
Yes, partly. So the question whether you gave a judgment or not, I think it's clear. You've given us the actual transcript on the day you gave the judgment. It's about a page. Then they go further and say, you also misled us when you said that you had given a final judgment. Your judgment was supposed to be revisited in the overall order. But when they asked you to revisit it, you refused. And you said that you had already made a final judgment, but you never made a final judgment. How do you answer that?
That is not correct, because they brought an application for my recusal after that, where I confirmed that I made that particular decision. They brought an application for me to revisit my previous rulings, and I repeated it. So it's not correct that I never made a decision.
No, whether it was final or provisional, that's really the substance of it.
Maybe.
Because I read the actual transcript you gave of the judgment.
May I have
It
some
says,
water?
yes, sorry, you want to have some water, yeah.
You may continue, Commissioner.
Yes,
Thank
so
you.
the actual transcript says, in the interim, in the meantime, it uses both of those words.
That was the initial ruling on extempore.
Yes.
When they brought the application at that particular time. But when you look at the following judgments that I wrote and the ones that I did extempore, it was emphatically stated that I regarded data evidence as a real evidence and not as documentary evidence. Maybe I should give you a little bit of meat to that.
Yes, please.
It was the data which was extracted from their electronic devices. And the Digital Forensic Laboratory, they did not just make copies of the contents, but they took pictures in the form of mirror images of those particular messages, that particular data. So that data was, some of it was even deleted. In fact, most of it was deleted. But through the forensic tool that was used, they managed to go deep and get it, that it was there and it was deleted on this particular day, on this particular time. So the accused persons, they wanted me to rule that it was documentary evidence. Because if it's documentary evidence, you have to call the author to come and confirm that this is me who wrote this particular aspect or this particular data. But then they were accused persons, and the information or the data that was being dealt with, it was something that they did or they wrote during the commission of the offense. So there was no way in which they would come and assist the state and say that we are testifying, I'm the one who wrote
No, I
this.
don't think there's a question about whether it was correct or not. It's really whether its status was final at the time you gave. Because my understanding of the explanation you've given in response is that you admit that you used the words in the interim or in the meantime, and you say that it should not have read in the interim because at the time you gave it, you intended it to be final.
That's very, very correct.
Yes.
But I must point out something, that during the trial, when you are listening to evidence all the time, that kind of the decision that you take or you took earlier, it might change due to the evidence that followed at the end of the day. So that's why there's a need to revisit that particular decision that you made earlier on, in case there is evidence that came later to contradict what was given there. So it's very clear that the decision was made. It was an unfortunate to have used the word in the meantime at that particular time. But if at the end of the trial, I had had different evidence that showed that that evidence was not supposed to be admitted as real evidence, I could have easily said so. So it remained real evidence through and through.
Yes. So, all right, I'm trying to make sure that I get the explanation. You're saying, it's true, when I gave the ruling, I said in the interim, in the meantime. But what I had in mind was that it would be a final ruling, not subject to revisitation. Because in the final judgment, you say, I'm not revisiting it because I've already made a judgment on it.
Exactly. The use of the words in the meantime, it was unfortunate in that English is not my first language. Because they said this will be proven that it was not their data. Then I said, in the meantime, as we have what I have in front of me, is real evidence.
Yes, so it was just an error.
It was just an error of the language there to use the word in the meantime.
Thank you.
But it was decided, I decided at that particular time that
No,
it's
Mr.
a real
Makamu,
evidence.
you know, I was cautioning another candidate yesterday that once they've got the answer, there's a tendency to expand, and then the more you expand, the more you defeat the answer. So
Thank
I
you
think
so
let's
much.
leave it here. Thank you.
Thank you.
So-
Thank you so much for the advice.
Do we have questions from the virtual platform?
Yes,
Yes.
CJ.
Chief Justice, I'll wait.
Or Commissioner?
Good afternoon, Mr.
Not from my side, CJ, thanks.
Thank you, Commissioner Mtweni. Go ahead, Commissioner Marumachai.
Thank you very much, CJ. Mr. Makamu, I think you, in your interaction with the JP of the division, it is quite clear that criminal matters where there are multiple accused persons, they take long, particularly where frivolous applications are being brought to disturb the process. I just want to find out, given your experience in the regional court, what strategies can be used to ensure that to some extent, these kinds of practices are dealt with, and trials where there are more accused persons can actually flow without any disturbance. Yes, I take it that parties have a right to bring applications, but what can be done from the judiciary to curb some of these frivolous applications? Thank you, CJ.
Thank you, Commissioner. Thank you, Chief Justice. There's no magic wand for it. The only thing is that as a judicial officer, you must stamp your authority and not tolerate some of the things that they may be coming up with to try and sabotage the smooth progress in that particular matter. But then it depends on your experience as well. If you have dealt with these matters like I have done so many years, it's easy for me to see where they are heading to and what I will say to make sure that we continue and avoid unnecessary delays. Because even in this matter, there were delays in the beginning, but at a later stage, I stamped it out. Thank you.
Thank you, CJ.
Commissioner Breitenbach, did you say you have questions?
Chief Justice, a follow-up on the question of Mr. Gothel. Good afternoon, sir.
Good afternoon, Commissioner.
In your reply to Commissioner Gotzel's question, I thought you said, but I may have misheard you, I thought you said the National Prosecuting Authority is a Chapter 9 institution. Did you say that?
No, I just wanted to say that it's an independent institution.
Okay, thank you. Thank you, Chief Justice.
Thank you, Commissioner Breitenbach. We've reached the end of your interview, Mr. Makamu. Unless there's anything you wish to raise with us.
The only issue that I would like to raise is to thank you for giving me an opportunity once again, to such an extent that you even remember that I was with you 2 years ago. So thank you for the opportunity. Thank you to all the commissioners.
Thank you. You're excused.
Thank you.